Once these sessions have been recorded, I will post them in the coming week or two onto YouTube. So everyone will have access to the YouTube channel link, which you can then access the lectures online if you wish to recap on anything that was discussed in the following 2 days. We'll also take some comfort breaks during the session just to have some water and so on. We'll also take lunch this afternoon at around 12 o'clock. We can see how far we get with the study material. We might manage with a half an hour lunch break or an hour lunch break, but we can discuss that as we progress with the day. Okay, and I think that's it from my side regarding the introduction. Are there any questions that anyone might have before we kick off regarding the exam, the format of the 2 sessions? You're welcome to ask those now. Hi, TK. TK, I see your hand is up. You're welcome to ask your question. I can't hear you, TK. Okay, we can come back to you, TK. There we go. You're on mute at the moment. Hans, you have your hand up?
Yes, good morning, everyone. Marco, I see your email says at SPUA and you're saying you are a partner. I don't know. Do you have your own company that works with SPUA or what?
No, I am a partner at Spur & Fisher.
Oh, okay.
Yes, I'm a partner of Spur & Fisher.
Okay, thanks.
Pleasure. My contact details, as you'll see, are provided in the slide. So if you do want to reach out to me, you're more than welcome to send me an email, even if you want to just have a quick chat about something over a phone call, you're more than welcome to set up a time with me. I always try and avail myself as best as I can to the students. I want you all to do well and, to understand the material as best as you can. So please do feel free to reach out to me if you are unsure of anything after our session or before the exams, in preparation for the exam. The exam isn't an easy exam. I can put that out there from the get-go. Last year, the average improved thankfully from the previous few years, and the average, even though it improved, was only 56%. So that is indicative of the challenging work, the volume of work, and the in-depth knowledge that you have to have on a theoretical basis of patent law. I'm not saying this to scare you, but more as a motivator that you do need to put in the time to do exceptionally well in this module. Okay, so we've already had our welcome. TK, I see your hand is up again. Maybe we can hear you this time. No, TK, we unfortunately still can't hear you. Okay. TK, you're also welcome to use the chat function if your sound isn't working properly, and then I'll take question from there if you're able to type it in. Okay, so the study material that you will need to use in preparation for your examination is obviously the Patents Act, which I did share the most recent amended version with you. So that will be your go-to. And as I said, you need to have an in-depth understanding of the Patents Act. The sections that are not provided for in the slides that we work through over the next 2 days will not be for examination purposes. So you'll see the first few sections of the Patents Act are not really dealt with. It's more the setup of the patent office, the functions of the registrar, the functions of the commissioner, which are not necessary for examination purposes. So together with the presentation for the next 2 days, you will use those to prepare for the exam, along with the patent regulations. The patent regulations are only those that are specifically highlighted in the presentations as well. It's a lot of regulations, so I don't expect you to know all of these, but please do familiarize yourself and know those patent regulations that are expressly stipulated or stated in these slides. Then for additional study material, you can have a look, if you have access to it, to the Dean and Dyer Introduction to IP Law, which I'm not too sure if you can see. It's this book over here. For anyone that is practicing as an IP practitioner, it is a very useful guide to intellectual property. It sets out the principles quite clearly and in a succinct manner, that you can understand without going into too much knowledge. So if ever you do need to have a quick guide, reference guide, I can recommend having a look at the Introduction to IP Law, and the editors there are Dean and Dyer. I still currently have the first edition. There is a second edition that is being published as we speak, but I don't know if it is available online yet. Then you'll see that I also refer to Burrell's, which you can see over here for those that are practicing trademark law. This is analogous to the Webster and Page book, very in-depth book on patent law. So if Dean and Dyer or I can't help, then Burrell's will be your next best bet. But as I said, this is only additional study material or as guides in preparation for the exam. The slides, the Patents Act and the patent regulations should be sufficient. These are merely just to clarify any topics that you may not have a good understanding of. Then you would have seen that I also circulated some articles that I have authored and published. Please do go through those as well. I have in the past asked some questions on the topics that were subject to those articles. So please do spend some time working through those articles that are circulated to you. Then in terms of case law, only the case law that is provided in the slides are necessary for examination purposes. I won't go beyond those cases. So it's only the cases that are provided for in the slides. In the exam, when you are citing these, please, I'm not going to penalize you if the citation is not 100% accurate, but please do try and get it as accurate as possible. So at least mention who the parties are to the cases. Okay, so then just to give you a quick agenda of the topics that we will be having a look at. So we'll have a brief introduction to patent law. Then I'll touch on the various international arrangements. I won't spend too much time on the international arrangements because a lot of this would have been discussed in your other Group 1 modules. So we'll just have a recap of the various international arrangements that apply to patent law. Then we'll look at patentability, which is mostly the Section 25 provisions of the Patents Act that I mentioned. So Chapter 3 of the slides is very important. Then we'll look at the procedure of filing a patent application, having a look at the various ways in which a patent application can be filed, the types of patent applications that can be filed. This chapter is probably the most boring because it is very admin intensive, very paper based, but nonetheless, we do need to go through it. There are some important deadlines, there are important provisions that we need to note in terms of when a case needs to be published, by when it needs to be accepted, when renewal fees are due, and the like. So we'll just need to bear with me on that chapter. As I said, it's not the most riveting chapter on patent law, but it is important nonetheless, especially in practice, and especially in the practice that I'm in. Then we'll have a look at corrections and amendments. These are corrections and amendments relating to the patent application itself, the patent specification, and any documents relating to the patent application or the granted patent. Then we'll have a look at the rights of a patentee, the rights of an applicant, what those rights are. Then we'll briefly touch on the licenses or the licensing provisions of patents. We'll look at compulsory licenses, dependent licenses. Then Chapter 8 deals with the restoration of a patent. So what are the provisions that relate to a patent that has lapsed where the renewal fees haven't been paid, what the procedure is to restore a patent, and what the requirements are to successfully restore a patent. Then also importantly are the grounds of revocation. So these are the grounds on which the validity of a patent can be attacked. So once a patent is granted, what grounds a third party can rely on in attacking the validity of the patent. As you know, South Africa is not an examining jurisdiction at the moment, so it is dependent on the courts to invalidate a patent. It is not the Patent Office's duty at this stage to assess the patentability of an invention. It rests with the courts. We will touch a little bit on some of the developments regarding South African patent law so that everyone is abreast with the new developments and where we currently are with substantive search and examination. Then we'll look at the infringement proceedings of a patent, and then appeals, offences and penalties, Chapter 11 or 12, those are for self-study. So we won't really be going through those during the workshop. It is quite clearly set out in the Patents Act and in the slides. So once again, I won't be spending any time on that unless there are questions regarding appeals, offences and penalties. Then TK, I see you did ask your question in the chat function. You said, according to SAIPL's Code of Conduct, the exam is fully online. How will it be written and how will we be monitored? So TK, previously, prior to the COVID pandemic, the exams were handwritten exams. And then due to the pandemic, it shifted to an online platform where the exams were written online. The functioning of the exam was outsourced to a third party that conducted the exams. And please note that this is only relevant to the students that are registered as SAIPL candidates. The Patent Examination Board candidates still have their exams conducted in person. So anyone that's wishing to qualify as a patent attorney or registered under the PB have their exams written, handwritten in person. But then going back to SAIPL and the online exam, it was a specific platform where these exams are conducted online. The questions are posed to you in an online manner, and you are then required to type your answers to the exams in, and you would submit it. How it is monitored is, I think you are required to have your camera on during the duration of the exam. And it also does not allow you to access anything on your computer apart from the examination itself, the exam platform itself. But I think a lot of you would have seen that the officer of SAIPL, Marie-Louise, is no longer employed at SAIPL, and a lot of the information regarding that examination platform is not available to the council members. So they are still currently looking at various platforms to use, failing which it might still be an in-person exam. But that will be communicated to you via SAIPL from Michelle Maguire that you would have been dealing with. So don't worry too much about the format of or the manner in which the exam will be conducted. If it's not online, it will be in person, and it will likely then be at some of the participating SIPOL firms where there will be an invigilator present at those venues. But as I said, that will be communicated. So I hope that answers your question, TK. Okay, great. Sorry, I'm still just admitting another candidate, and then we can kick off with the material. Before we go ahead, are there any questions, any further questions? Okay, well, I hope everyone's ready then, and that you've had your cup of coffee or 2 cups of coffee, because it is going to be a lengthy day. All right, let's get going. Please do excuse my slowness. I'm managing 3 various screens, so it is a bit tricky to navigate everything. Okay, so where do patents come from? So I'm of Italian heritage, so I'm quite proud to say that patent law first found its roots in Renaissance Italy. Isaac, you attended the WIPO summer school, I see. So you'd probably have seen quite a bit of this already. So I do apologize for those that have gone through this. But for the benefit of those that didn't attend the WIPO summer school, I am going to just work through this again. So in 1416 is the first recorded record of some form of a monopoly right granted for an invention. And that was granted to Sir Franciscus Petri in Venice. And that was for a structure for fulling fabrics. So it was the Great Council of Venice at the time that awarded the first patent for this technological innovation for Petri from Rhodes in respect for a device that was used to transform wool into felt. So the wool would be sheared off sheep, and then it would be cleaned of any debris that may have been left in the wool, and that would then be converted into felt through this pestle that was used to fill the fabrics. And this was then the first introduction of the right to exclude others from using an invention. Then moving on to 1421, again in Venice. And now if you imagine Venice, and if you've been fortunate enough to travel to Italy and to Venice itself, you'll know that a lot of the architecture, a lot of the structures there used very heavy materials, a lot of marble that was used. And considering the canals of Venice, it was difficult to move this material around. So in 1421, Filippo Brunelleschi devised a novel boat design that was used to move these massive marble slabs through the canals of Venice. And again, the Great Council of Venice awarded him this right to exclude others from using his invention. So he was given this monopoly, a negative right to exclude other people from using the invention, and so that he was the only one to benefit from the invention. But then in 1474, so about 60 years, 58 years or so after the first known form of a patent right being granted, Venice actually codified the patent law, and that was known as the Statutes of Industrial Brevets. And that is the earliest codified system for patent law anywhere in the world. And what's interesting about this codification is that a lot of what was held in this codification is still very relevant to patent law today and still forms the foundation of patent law. So do forgive me for reading through this, but it is important to see how the law has developed, or rather hasn't developed, in terms of what the fundamentals are of patent law. So if we take the extract relevant from the Statutes of Industrial Brevets, this is a translation thereof. It says, each person who will make in this city any new ingenious contrivance not made hereto in our dominion, as soon as it is reduced to perfection, so that it can be used and exercised, shall give notice, it being forbidden to any other to make any other contrivance in the form and resemblance thereof, without the consent and license of the author up to 10 years, who shall infringe, be forced to pay him the sum of 100 ducats, and the contrivance immediately destroyed. Now, the reason why I say this is so relevant and am I back?
Yes.
Hi, everyone. Are you able to hear me? Okay, perfect. Thanks. Okay, so then to carry on, I apologize for that. Please do give me a heads up if I lose connection again. So as you'll come to learn during the course of today, one of the most important requirements for patentability is that the invention must be new. That means it must never have existed previously prior to the filing dates of the application for that invention. So as you can see, yeah, again, we have this novelty requirement that an invention must have. And it says not made heretofore in our dominion. So at the time, the novelty requirement was only within the confines of Venice, or within the extent of which the law was applicable. In South African law and worldwide generally, an invention must be novel throughout the world. So it isn't just based on a territorial nature of novelty, it is a worldwide requirement of novelty. So that is one difference here, but it's interesting that they did expressly state what the confines were of where that invention needed to have novelty. Then as soon as it is reduced to perfection, again, very interesting in terms of South African law, because one of the grounds on which a patent can be attacked is that it lacks utility. So a person is not able to put that invention into practice when performing that invention. So again, it has to actually function. And then so that it is used and exercised. So these are the grounds on which another party could have been infringing the patent rights. Then it being forbidden, so it's an exclusionary right, as is the current dispensation, to make any other contrivance in the form and resemblance thereof without the consent and license. So again, very interesting to see that there were provisions made for a proprietor of the invention to actually license the invention to a third party. So to enter into a contract and to permit another person to make use and exercise that invention. So very similar to what is provided for today. Then The duration of the monopoly that was awarded to the patentee was for a period of 10 years. In South Africa, it's a 20-year monopoly, and that is the case generally across the world. It's a 20-year monopoly right. Then if a party is found to infringe, there is again a remedy available to the patentee or the holder of that invention. And that was then the sum of 100 ducats, and the contrivance must be destroyed. So very similar again to the remedies that a person would have in South Africa, where if there is an infringing article, one of the remedies is that that article be offered up or sent for destruction. So that's just an illustration of what the statute looked like, just for you to have a look at. Purely just for you to see where it arose from. So now we know where the patent law originated from, but what is the importance of intellectual property, and not just patents as a whole, but intellectual property? And I think one of the most important ways to understand intellectual property is to consider it as an asset. These rights are intangible assets, so it's not necessarily something that you can see. That can be reduced into a material form, or the products of a patent, for instance, can be reduced into a material form. But the rights themselves are intangible assets, so not something that you can hold or feel or see. But when you start to compare an intangible asset with a tangible asset, such as a house or a car, it becomes a lot more clearer when dealing with intellectual property, if you deal with it in a similar manner in which you would a tangible asset. A tangible asset such as your house, for instance, can be sold to a third party. And the same applies to an intellectual property right. It is capable of being sold to another party. You're able to rent out your house in return for an income. And that is very analogous to a license agreement, where you're able to license out the intellectual property right to a third party so that they have the right to use or to exercise it without infringing on that right. And it's the same with a rental agreement for your property. You are permitting somebody to make use of your property. If they weren't, they would be trespassing or squatting in your premises. You might also have the option, if you're thinking of a license agreement, to only rent out a specific room in the house. And the same applies with IP. You can vary it contractually, what use a third party would have. So is it only to manufacture the invention? Is it only a certain part of the process that can be licensed out? What is the duration of that process? So important to make this distinction or comparison between intangible and tangible assets, and how they are so similar, and how you can give value to these intellectual property assets when you consider it as a tangible asset, just to make it a bit clearer. But if you look statistically at the importance of intangible assets, and specifically intellectual property assets, up on the presentation, you'll see that I have a graph here. And this is taken from this Intangible Assets Financial Statement Impact Comparison Report. This is from 2019. And what they did was they had a look at the S&P, or Standard & Poor's 500, which is a stock market index used to track the stock performance of the 500 largest companies listed on the stock exchange in the United States. It is probably one of the most important and most followed equity indices. But the reason why I have provided this is, if you look at the comparison between tangible assets, which are those in gray, and the intangible assets, you can see how there has been a shift away from the S&P 500 companies' assets, with a move away from their tangible assets, and how their company assets value increases and far outweighs what their tangible assets would have been at that stage. And it also is very indicative of the type of technologies that have developed over the various years. So if you look at 1975, the 5 largest global companies by market cap: Procter & Gamble, General Electric, 3M. So pharmaceuticals, IBM is also there. So the development of personal computers and processing chips, General Electric, which dealt with a lot of various electronics. So they had a much larger tangible asset base. And then you'll see a shift gradually moving on to where, looking at 2018, you can see that all those companies that would have had large tangible assets in their portfolio and in their company value has shifted to those more in the computer space. So you've got Apple, Alphabet, Microsoft, Amazon, and Facebook. So all their IP sitting in their intangible assets. So I think this is a very good illustration to see how there has been a shift from the importance of tangible assets to how important intellectual property is and the intangible assets that these companies have. So again, this is just a breakdown of the various intangible assets that were considered for each of these companies. But you'll see that out of these 8 various types of intellectual properties, 5 of those intangible assets are identified as intellectual property. So more than half of the various types of intangible assets themselves are related to intellectual property. We've got intellectual property as we know it: your patents, copyrights, trademarks, trade secrets, know-how, plant breeders' rights would also fit in there, where you've got the brands, so more relating to trademarks, the goodwill associated with those brands, the reputation, data, also very important intellectual property. So just again illustrating the value of the intangible assets and how intellectual property plays such an important role in the books of these companies. So what I've put up ahead here is an illustration of the first incandescent light bulb that was patented in 1880 by Thomas Edison. This is a US granted patent, and the illustration of the drawings from the patent document itself from the United States. The reason why I've put this up is just to illustrate how there's been a shift in the technology relating to this light bulb. It was a very simple device. You had a glass bulb with a material that could conduct electricity and which would be incandescent when a current was passed through it. And yeah, I've actually got the patent claim for you. So it was an electric lamp for giving light by incandescence, consisting of a filament of carbon, so the section over here, of high resistance made as described and secured to metallic wires as set forth. So as soon as a current was passed, this would then illuminate. Now, if you think about the technology that we use today when it comes to light bulbs, you know, your LEDs, halogen lights, and how there's been a change in the type of technology being used when it comes to illuminating a room, a vehicle. It all started from this first granted patent of a fluorescent light bulb. And there have been various reasons for the changes in its technologies. This was very energy intensive. It required a lot of energy to illuminate it. The lifespan of this light bulb was also very limited. And if you think today of the LED lights that we use in our homes, they are far longer lasting. Those bulbs can last for 3 up to 5 up to 10 years. they use a lot less electricity as well. So there is some function that the new technology is providing to consumers. And that is what the purpose of inventions is to develop technology and to solve solutions to problems that we may be experiencing. Then just a fun illustration to have a look at this invention on the screen over here, which was again granted in the United States in 1958 to G.K. Christensen. Anyone want to give me a go as to what this invention is? Or somebody should surely know what this is. I'm sure you may have stood on one as a child and probably experienced the worst pain in your life.
It's a Lego block.
Here we go. Yeah, so that was a Lego block. So obviously the patent on this Lego block would have expired, but can you think of any other intellectual property relating to this Lego block that might still be valid today or still enforceable? Hans, do you know the answer?
No, I wanted to answer that
Okay.
Yeah.
Anyone else? What type of intellectual property do you think still exists in this Lego block?
Buildings?
No? What type of intellectual property?
Trademarks.
Yeah.
The
Okay.
design?
So I heard a few mentions there for trademarks. So remember, a trademark can exist into
Literally.
perpetuity, provided the renewal fees are paid every time that they're due. So in South Africa, a trademark is renewed every 10 years. So provided that trademark is renewed, it is still a form of intellectual property that exists in this block. Remember that a trademark can also protect a shape mark, and this is very clearly a shape mark, and the trademark still exists for this Lego block. So it's one of the things that I want you to take away from this morning's session as well, is that when you are looking at intellectual property, try and look at a product and identify the various forms of intellectual property relevant to that product. It might not just be an invention, there could be a trademark. Back then, this would have been registrable as a design as well for the shape and configuration, the various patterns on it. Again, a design is only limited, or an aesthetic design is only limited for 10 years. But in practice, when assisting your clients, you need to be able to give them the best advice possible on how to exploit their products in order for them to have maximum benefit from their intellectual property. Okay, then another fun one to have a look at. We've got the Gillette razor blade, which again was patented in the US. Look, I'm sure these were patented in other countries as well. I haven't gone into the research of that, but these are just some fun illustrations to show you of some of the inventions that were previously patented and which still form a benchmark for a lot of newer technologies. Even though you've got your new Gillette Mach 3 razor blades and that, I still think these ones work the best, personally. And they're probably a lot cheaper to use as well than the current razor blades. But this was patented in 1904. Then over here, we've got the patent for the first winged aircraft that took flight by the Wright brothers, shortly after the patent for the razor blade, and that was in 1906. So just some fun illustrations to show you some of the patents that were previously granted. But then if we bring it a bit closer to home, particularly in the practice that I deal with, my practice is solely focused on dealing with foreign clients. So I don't deal with local inventions, local clients. I file applications for foreigners that wish to protect their rights in South Africa. But there is a lot of development that has taken place and still does take place in South Africa that we mustn't forget and be quite proud of as South Africans. The first one is that of Pratley Putty, and that was the world's first epoxy putty that was invented by George Pratley in 1960. Sorry, I'm just trying to get my cursor to move onto the correct screen. There we go. But what's interesting about Pratley Putty is that it was used on the Ranger spacecraft that went to the moon in the mid-1960s. So very nice invention that was developed in South Africa. Then moving on to the Smart Lock safety syringe. Again, another South African invention. And this arose during the HIV pandemic that South Africa and the rest of Africa were faced with, where medical practitioners, if they weren't careful enough or if an accident arose, would mistakenly inject themselves with a syringe that may have been used on an HIV patient, and then the virus would have been transmitted to them. But the Smart Lock safety syringe was then developed in South Africa to ensure the safe use of the syringe and to avoid, accidental exposure to the virus by injection. Okay, then we also have Sasol. Anyone that dabbles in the stock market will see that Sasol is doing incredibly badly at the moment. But Sasol has created a lot of technology in South Africa, and was the world's first and the largest oil from coal refinery. So to extract oil from coal. Then another interesting one, which I'm sure many of you may have used before if you've got a squeaky door or something that requires lubrication. That is Q20, which was invented in 1950 in Pinetown in KwaZulu-Natal by Mr. Robertson. At the time, VW Beetles were very popular in South Africa, but VW Beetles were notorious for stalling in wet weather. So he devised this product, the Q20 lubricant, which was then used as a compound to displace water to prevent water from entering into the distributor caps and therefore preventing the cars from stalling. Then you've got the CAT scanner, which was developed in Cape Town by a physicist, Alan Cormack, and his associate, Godfrey. Technology that's used worldwide, and that's incredibly important for imaging of patients. Then you also have, anyone want to give this one a go? Who's from KZN? Along the coast. Okay, do we know what this is? Surely someone should know what this is. Okay, if not, these are known as yes. Yeah, go for it.
I think it's a dolos, but I don't know if there's an English word for that.
Yeah, Lisa Maria, it is a dolos. That is the correct word for it. So again, a dolos, which is a very large and usually shaped concrete block, each one weighing about 20 tons. And this structure is designed to look this way to break up wave action and then to prevent harbor walls from eroding. And not just harbor walls, but also the coastal perimeters of the country from eroding. So you'll see the dolos is placed in very critical areas across the coastal regions of South Africa to prevent erosion from the waves inland. Unfortunately, this was never patented. I don't know the reasons behind it. I just don't think intellectual property was at the inventor's fore of mind, or some dispute arose between the parties that were involved. So, if you can imagine, had the dolos been patented, this is used across the world currently, how much profits they could have extracted from this invention. And it just speaks to how important intellectual property rights are in ensuring that your IP is protected. Then another fun one is the creepy crawly, which was invented in Springs, yeah, close to Johannesburg in 1974. So that's an automatic pool cleaner, and again, used worldwide. So some fun inventions that have come from South Africa. More recently, one that comes to mind is I won't necessarily say an invention, but definitely an application of intellectual property, was the transplanted ear, where the professor from University of Pretoria successfully transplanted an ear by 3D printing, the various parts that form an ear. So your little anvil, your stirrup, very intricate parts of the body, the smallest bones in the body. But again, something from South Africa. And I mean, even the same with the heart transplant of Chris Barnard. So a lot of interesting development. Also in nuclear medicine, South Africa is a forerunner in the production of nuclear isotopes that are used in medical treatments. Then there's also some weird and wacky inventions that have been patented previously. This one is an anti-eating face mask. Funny enough, from the description of the invention, it's mainly for those who are exposed to food constantly, such as chefs, cooks, restaurant personnel, or the like. So people come up with some weird and wonderful inventions. I've even seen some with chicken goggles to prevent chickens from pecking each other's eyes out. Some strange things. I don't know if they've ever been successful on the market, but these are the types of things that people come up with. And I mean, if it is new and inventive, it is still patentable, no matter how weird we think it might be. Okay, then if we have a look at the nature of intellectual property rights before we delve into patents specifically, these are concepts that are created through innovative and creative efforts of the human mind. So intellectual property is exactly that which is stated in the term that we use to describe it. It's intellectual property. It is property that is developed by the mind. And property, again, that intangible asset that is devised through human ingenuity, human creativity, and the exploitation of a person's mind to actually develop something, whether that be a design, an invention, a new logo, a trademark that they use in protecting a business. So everything where, creative efforts, human effort has been applied in developing something is intellectual property. Intellectual property rights are creatures of statute, so it is a right given in terms of the statutory requirements. The rights are territorial in nature, so you need to seek protection for intellectual property rights in the various countries where you wish to exploit that intellectual property. So there's no such thing as a worldwide patent right or a worldwide trademark. This is often the case, and the perception that the public has is that if I file a patent application in South Africa, that protection extends globally, and that's not the case. The reason being is that the rights are granted to you by the government of a specific country. You need to obtain that right from the various countries. The laws obviously differ from country to country. They are free states with their own requirements and procedures and processes that need to be followed in obtaining those rights. There are obviously treaties in place that allow for the streamlining and protection of rights on a more global scale that a person can exploit, and we'll look at those in greater detail when we touch on the procedures relating to patents. But in terms of trademarks, you have the Madrid Protocol that allows for more global accession. You also have territorial rights. If you consider the European Union or the European Patent Office, where you can obtain patent rights in the various member countries of the EU. But again, it's an application that needs to be made to that office for the right to be granted. So if ever anyone tells you that you have a worldwide patent, tell them that they're talking rubbish. Then, as I mentioned earlier, when we had a brief look at the tangible versus intangible assets, intellectual property in their very nature are intangible in their conceptual form, but these can be rendered into tangible products. So, you might have the idea of the patent, and the patent right that is granted to you is intangible, but the product of that patent right can be rendered into a tangible product. So the patent right over this bottle, for instance, there you go, you can see the bottle. If there were a patent on it, which I highly doubt there is at the moment, but if there was a patent over this, the patent itself is an intangible asset, but the product itself of that patent right is a tangible asset. Then again, as we did touch on this, that these rights are assignable, so you can transfer the ownership of the intellectual property rights from one party to another party. You can deal with it, as we discussed, as you would a tangible asset, where you are capable of licensing that product out. You are able to dispose of that right if you no longer wish to maintain that right by not paying the renewal fees or allowing it to go abandoned. And then again, we've spoken quite extensively on the value of intellectual property, and that is one of the purposes of obtaining intellectual property rights, is because they have significant economic value. That doesn't mean that every invention has significant value. It's often not the case, but you don't want to miss out on that boat. If you take the Dolos, for example, the creator of the Dolos probably thought that there's not much value to this product that I've developed, but had they had IP rights on that, they would have been very, very rich today. Again, all creatures of law. Then an interesting question is, are intellectual property rights immovable, considering that they are intangible assets? And then you can have a look at the Oilwell versus Protec case, and also some of the exchange control provisions regarding intellectual property rights. So the exchange control provisions where you are exporting intellectual property out of South Africa. So you have a South African patent that is owned by a South African company, and you're selling it to a Chinese company, as an example. That is an export of the intellectual property right out of South Africa. The exchange control provisions previously held that where capital is exported out of South Africa, exchange control approval is required from the South African Reserve Bank. This then went to court, and the court found in Oilwell that intellectual property is not deemed to be capital and is not that it is immovable. It is not movable. So it's not capable of being exported outside of South Africa. Then the South African Reserve Bank were very clever, because they then amended their regulations dealing with exchange control. And in the very definition of capital, they included intellectual property right as a form of capital. So now whenever you are assigning intellectual property from one company, a South African company, to a third party that is outside of South Africa, not registered in South Africa, you are required to obtain exchange control approval, because it is considered an asset leaving the country that might have immense value. Okay, but exchange control approval is beyond the scope of this, so you don't need to worry too much about that. Okay, so we've had a brief look on what are the nature of intellectual property rights, but then what is a patent? Before we move on to that slide, who wants to tell me, what do you think a patent is? Are there any takers? Anyone? What's a patent? Constant? Go for it.
So it's just a form of an intellectual property right that is granted to an inventor or an holder where they have a monopoly over this product or the invention for a certain amount of time.
Yeah, perfect. So that's exactly what a patent is. It's a monopoly right that is granted by the state to an inventor or a party to which those rights have been transferred to exclude other people from exercising that invention in specific manners, which we'll have a look at, specifically for an invention. What is an invention? We'll have a closer look at that so that you have a clear understanding of what an invention is and what is capable of being protected by virtue of a patent. So looking at this slide, just to repeat myself then, it says that it's a statutory monopoly right that provides for the protection of an invention. It's a right to prevent others from exploiting the patentee's invention for a limited period. And we refer to it as a negative right because it's not something that is given to the proprietor of that patent to do. Rather, it excludes other people from exercising certain actions over that invention. And that's why we refer to it as a negative right. But then in return for the grant of the patent, so once the patent office issues you with your latest patent certificates and it's proceeded to grant, the patentee must fully disclose the invention so that others may exploit it once the patent has expired. Okay, so that's the crux of what a patent is. But what is the benefit of a patent? What is the purpose, rather, of a patent? Why would one obtain patent protection? Apart from excluding others from exercising your rights and you being awarded a monopoly for 20 years to exclude others from performing that invention, what other benefit can you think of in obtaining a patent right? Constant, yes, you again. Go for it. Thanks.
Sorry, so yeah, just what I can recall, the main part of it is to foster innovation and ingenuity within the country and just globally with regards to different types of inventions.
Yeah, so that's probably one of the most important reasons for obtaining a patent. So as you would have seen on the slide in front of you, is that in order for a patent to be granted, the patentee has to fully disclose how that invention works. And thinking back to Thomas Edison's light bulb, to the light bulb that we have now, without the disclosure of that invention, barring reverse engineering perhaps, the public is able to have access to very vital information on how to perform an invention and to see how further they can improve on that technology. Again, considering the light bulb example, where Thomas Edison's light bulb used an immense amount of energy in order to become incandescent. The lifespan was incredibly short. To the technology that we have today, where there's a longer lifespan of an LED bulb, it uses far less energy as well. And that wouldn't have been possible without the disclosure of those inventions. And in order for a given invention to be further built on. So remember that a patent is not necessarily granted for an invention that is groundbreaking new. It's not the iPhone 3 with a touchscreen that was first released to the world, where it's, groundbreakingly new technology. Any improvement on an existing technology is patentable, provided that that improvement is new and inventive. And that's the way that technology develops and how we can continuously innovate on technology is from this public disclosure that other parties can see how best to improve on an existing technology. So as you can see, it encourages improvements in technology, thereby driving innovation. Obviously, there has to be some type of incentive, and that is then to reward such improvements. And how is that rewarded? It is by the patentee having an exclusive monopoly over that invention, where they can either sell the product themselves, they can manufacture the products themselves, or they can license the invention to a third party and obtain royalties for the develop or for the manufacture, sale, distribution of that invention. Also, if they themselves wish to sell the patent rights, they're able to do so at, for a sum that they feel appropriate, the value of what that patent might be. Then again, just to touch on, it allows for us to obtain the disclosures of these improvements in technology. It also encourages the application of the invention in society and inventiveness. Again, a patent right also acts as a deterrent to infringement. So if a third party is aware that a type of technology is protected by a patent, they're far less likely to infringe on that person's rights. They might even try to design around it, and by designing around it, thereby also again improving on the technology. And ultimately, it is this quid pro quo principle that underpins what a patent is. So in return for the disclosure for the invention to the public by the proprietor of the invention, you are awarded a limited monopoly of 20 years by the government. Is everyone happy there? Yeah. So this is just an illustration of what a patent certificate looks like on the letters patent document that is issued by the South African Patent Office, just so that you can see what eventually is given to a proprietor of a granted patent, merely just for illustrative purposes. All right, and that then covers our introduction for this morning. Are there any questions that anyone has on the introduction? Yeah, no, it seems we're all good. I think let's take a 15-minute recess and then we'll reconvene at 10:30. If you do come up with any questions, please do share them with us when we return. So I'll see you then at 10:30 again. We will reconvene and discuss international arrangements. Welcome back, everyone. Okay, we can move on to the next section of today's workshop, which is a discussion on the international arrangements relating to patents. Again, if you wouldn't mind turning your cameras on, that'll be great. Thank you. So the first treaty that we'll have a look at is the Paris Convention for the Protection of Industrial Property. And the Paris Convention provides for three overarching principles, or aims to provide for three principles. And that is the first being the principle of priority right. So it says that any person who has duly filed an application shall enjoy, for the purpose of filing corresponding applications in other countries, a right of priority for a certain period after filing the first application. So what this means is that if an application for a patent is filed in one of the Paris Convention member countries, the applicant for that invention, or whoever's obtained the rights to that application, may file an application for that invention in another Paris Convention country within a period of 12 months. So if an application for patent was filed in the United States, as an example, and they wish to obtain patent protection in South Africa, they have 12 months from that first filing date in the United States within which to file an application in South Africa. And that period from when that application is filed will there not be a disclosure that is considered a novelty destroying event or novelty destroying disclosure, because of the principle of priority right. So anything is considered novelty destroying before the filing date of that first filed application in the United States. So when that application is first filed, an applicant has 12 months within which to file that application elsewhere. And that is what we mean by the principle of priority right. Then secondly is the principle of national treatment, and this is that member states must grant the same protection to nationals of contracting states that it grants to its own nationals. So there cannot be bias dependent on a person's nationality or country of origin. The same rights that South Africa would provide to South Africans are the same rights that must be awarded to an American, as an example, for their application. So there cannot be any discrimination, and the principle of national treatment is then applicable to foreigners filing applications in South Africa or any of the Paris member convention countries. Then we also refer to the common rules of the Paris Convention, and that is purely the set of rules that are set out in the Paris Convention that aims to harmonize the intellectual property laws in the various contracting states. This is a convention that is administered by WIPO, and South Africa became a party to the convention in 1947. But in terms of patent law, the most important takeaway from this is the principle of priority right. It is something that is used in practice every day, where a foreign national will file an application in their country and then seek protection in another member country of the Paris Convention. Then you also have the trade-related aspects of intellectual property rights, or TRIPS. Again, used to harmonize the various forms of intellectual property rights, where it sets out minimum standards. So it establishes international minimum standards for the protection and enforcement of intellectual property rights for parties to TRIPS. Again, as with the Paris Convention, where we have the principle of national treatment, TRIPS also makes provision for the national treatment principle. So a member must accord such protection to nationals of other member countries on a basis broadly corresponding to the principles contained in major international conventions relating to intellectual property law. So again, there cannot be any prejudice, and Furthermore, it is the most favored nation treatment. So that national treatment should be in a form where it is the most favored nation. So the best principles that apply in a country that would be considered the most favored nation in terms of their intellectual property should be applicable to all member countries of TRIPS. So it requires member countries to adhere to the principles of non-discrimination as embodied in the requirements of national treatment and the most favored nation treatment. So South Africa has been a member of the World Trade Organization since the 1st of January 1995. Prior to it being the World Trade Organization, it was otherwise known as GATT, and that was South Africa was a member of GATT since the 13th of June 1948. So any member of the World Trade Organization must adhere to the TRIPS provisions. TRIPS, you'll see, is not so applicable to patents, but is more relevant to copyright law. Then probably the most important, or one of the most important, apart from the Paris Convention relating to patents, is the PCT, or Patent Cooperation Treaty. And when we look at the various procedures regarding patent applications, we will delve into the PCT in greater detail. But the PCT provides for a unified filing process for patent applications in order to obtain patent protection in the various contracting states of the PCT. So you have the PCT that many countries have ratified. Currently, it's 157 member states that are members of the PCT. And you are able to file an international patent application or a PCT application for an invention. And why would one do this? It simplifies the filing procedure, but the greatest benefit is that that international application undergoes examination. So a search is conducted of the invention and it undergoes examination. So an applicant is able to obtain a clear understanding of whether their invention is viable and will be successful in obtaining granted rights in the various countries. So when I mentioned that the PCT application is an international application, it doesn't mean that those rights, that there's any enforceable right for an international application. Again, there's no such thing as a worldwide patent. So that international application that is filed during the international phase still needs to be nationalized in the various countries across the world in order for an applicant to be granted enforceable rights in the various countries. So South Africa acceded to the PCT in 1998 and was implemented into our law in 1999. One of the benefits as of the PCT is that it increases the amount of technology transfer because of the various applications that are being filed globally, and whether a person would choose to file an application via the PCT is very dependent on a client's budget, on the market where they seek to obtain protection. If they're filing an application in one or two countries, then I wouldn't say that it's necessarily advisable to file an international application. They can file directly via the Paris Convention. So if they filed in their home country, they can file within 12 months into South Africa, as an example, instead of going the international route. But if you file a PCT application, you would then designate the various countries where you're seeking protection, and you would need to still nationalize those rights into the various countries. But don't be too confused by the PCT at this stage. We'll look at a proper timeline and go through the various processes that take place during the PCT. Hans, you have a question?
Yeah, thank you. I wanted to ask, are we allowed to make amendment through the PCT for the jurisdictions that we say maybe the applicant applied on? Say,
yeah,
I make one amendment and then it goes through all the jurisdictions.
Yeah, so that's one of the benefits of filing an international application, is that you are permitted to make amendments, and two of the major provisions are Article 19 amendments and Article 34 amendments of the PCT. An Article 19 amendment is where an applicant voluntarily wishes to amend their application in the international phase before it is nationalized. Then you also have an Article 34 amendment where you have made amendments in response to the examiner's objections in their written opinion. And those amendments, in terms of South African law, that are made in the international phase are then deemed to be amendments made in South Africa as well. So even though the application hasn't been filed in South Africa yet, once it is filed, those amendments form part of the South African specification. And that's generally the case in most other countries, but it would be dependent on their national laws whether that is the case. But for South Africa, that is what our current law holds. So that any amendment made during that international phase is deemed an amendment in South Africa.
Yeah, because sometimes it becomes difficult because you might have to amend based on what that the country's laws apply to, and there's another country and they have different laws and all that. So I think it might be a bit difficult to make an amendment, maybe based on the invention itself.
Yeah. Look, it obviously depends on what objections are raised during the international phase. If it relates to novelty, then you could overcome that novelty. Again, as you said, it depends on the various countries, what their national laws hold as well. But that's why once those applications are nationalized, they still often go through examination in their own jurisdictions, and then they would still have to respond onto those in their own countries.
Okay, thanks.
Pleasure. Okay, but as I said, we will have a closer look at the PCT in greater detail. Then just some other international arrangements to be aware of is the European Patent Organization. So in this case, you'll file one patent application to the EPO and designate the various countries where those rights should be nationalized. So it's a bundle of rights that are then granted. Then in Africa, we also have a REPO, which is the African Regional Intellectual Property Organization, and they are based in Harare, Zimbabwe. And that is mostly the previously English colonized countries that are part of a REPO with similar laws. South Africa is not part of any of these regional countries or regional filing strategies or arrangements. So in a REPO, you would also file an application into a REPO and then designate the various countries, but they still need to then be designated for rights to be granted in the various member countries of a REPO. So it's not one patent right that's granted. They still need to be nationalized in those various countries by way of designation. So you'll pay higher official fees for the various countries that you designate. Then you also have OHAPI, and OHAPI focuses more on the previously French colonized countries in Africa, again with similar laws in place due to their pasts, and more the northern territories, central to northern territories of Africa, where there are countries that are members of OHAPI. With OHAPI, however, it is a bundle of rights. So you'll file one OHAPI application and it gives you protection in the entire region. So there's no nationalization into the various countries. So if infringement takes place in one of those countries, it is considered infringement in that entire region. The other problem is, though, is that if the patent is revoked in one of the member countries, then you lose your entire bundle of rights across the entire region. So it's basically one patent that is granted across a broad region of Africa. Okay, so let's have a quick look then at the PCT timeline, seeing that we have discussed it at some length already, and what the process is when filing an international application. And because this is so important in our practices in South Africa, because most applications that are filed in South Africa for patents generally stem from an international PCT application. So what will happen is you will have an invention where you would file an application. Now, you can file that application for a patent in your home country. So let's take the USA as an example, where you will file a priority application in that country. In terms of the Paris Convention, and because the PCT is considered a Paris Convention country, even though it's not a country, so to speak, you have to file that international application within 12 months of the first filing of an application. Okay, so in terms of Paris Convention, you have to file an international application within 12 months from your first filed application. Again, we will touch on this at some length later on, but just to give you a brief overview of what goes on in the international phase. It's not necessary to file an application in your country. First of all, you can file an international PCT application in the first instance. So you'll file that application with the receiving office. Now, receiving office is the patent office of the country where you file the application, and that is a member of the PCT. So South Africa's patent office is also a receiving office and can receive an application for a PCT application. The applicant will then designate in their application which searching authority they want to use to conduct the examination of that invention to determine whether it is patentable or not in terms of the patentability requirements of novelty, inventiveness, and industrial applicability. So the applicant, once they've designated their searching authority, the application will be examined during the international phase, and that searching authority will then prepare a written opinion. And in that written opinion, they will set out what their findings are as to whether the invention is deemed to be novel and inventive and industrially applicable or not. If it is found not, you don't lose any rights. The applicant can still pursue the invention. They can respond to it by filing amendments to overcome any objections, or they can abandon the application if they so choose. So it's all up to the applicant what they wish to do with that application. But as I mentioned to Hans earlier, there is an opportunity during this phase, international phase, to make any amendments to the specification for that invention during the international phase. Okay, once it has undergone its examination, those search reports are then communicated to the various designated officers. And then it's upon the applicants to nationalize those applicants, that international application. So the applicant will then reach out to their various patent attorneys across the world and ask them to please nationalize that international application in their country. But I think it's very important to understand what the benefit of the PCT is. And can anyone give me an idea what they think the purpose or the benefit is of filing an international application? Hans, I'm going to pick on you. Seeing as you asked me 2 questions, I can ask you a question. What is the benefit of filing the PCT?
Wow. Okay. Thanks. I think basically is financially it's less and less costly, and also if you have an invention that you think can prevail in different countries, but not all, then you can put it. So basically, it supports different countries that are affiliated within the PCT.
Okay. Thank you, Hans. Let's hear what Constance has to say.
I think that,
Sorry, there's Constance and Constant. Let's give Constance a chance first.
sorry.
No, it's fine.
All right. I think it's a simplified process of filing a patent application in foreign countries. So I think
Okay.
PCT helps with like a simplified process of filing patent application in foreign countries. And with that as well, there's also like a prior assessment of patentability criteria by the patent examiner. Yeah, those are the two advantages I can think about.
Yeah. And then Constant, you also had a response?
Yeah, so I think it's the streamlined process, like you said earlier, with regards to how the processes happen. And then also it's one part, it's like it doesn't destroy the novelty requirement in the different countries when you make use of the PCT as well.
Yeah. Okay, thanks everyone.
Marco, I think
yes.
it's also priority rights. So
sorry, can you repeat that, Paz?
Priority rights. So
yes,
you're able to get
Yeah.
So you're able to take priority rights.
Yeah. Yeah. Okay. So that's Hans. You mentioned that it might be less costly. Filing an international application itself is quite expensive, but further on down the line, it might save the applicant money. And the reason why I'm saying that is because it comes down to Constance's point that you obtain patentability or an indication of the patentability of an invention prior to nationalizing in the various countries. So if you took the example where you filed an application for patent in various countries individually without going the PCT route, you'd have to pay examination costs, filing costs, all those official fees applicable relating to those applications in the various countries. And only then to find out in each individual country that the invention is not actually patentable. So you've spent an immense amount of money paying some of these fees, and a lot of these fees you have to pay up front are then wasted. Whereas if you're filing an international application, although it is expensive, you have a clear indication before nationalizing that invention in the various countries whether the invention is patentable or not. I mean, the search reports that come out from the PCT are credible. They are very good. So an applicant can make an informed decision before expending further money where they wish to nationalize an invention as to whether it would actually have success of becoming a granted patent in the various countries. Then also Pius mentioned that you can obtain a priority right. So as I said, you can file a PCT application in the first instance and obtain priority rights. Constance also mentioned that you have a longer period within which you are protected against a novelty destroying intervention. And that is because once you file your international application, at this point, so if the claimed priority from an invention, as I said, you have 12 months within which to file. And then from that international filing date, you have to file your national application within either 30 or 31 months from the international filing date, depending on, from the priority date. I apologize. So it's 30 or 31 months from the first filed application within which you need to nationalize. And whether it's 30 or 31 months depends on the various countries' national laws. Razzia, you had a question. Not sure if we've lost Razzia. Razzia, I can't hear you.
So I see you asked about the POA. Yeah, so the first, she did it for yeah,
I don't know if that's for us or not.
It's Arabic, yeah.
Okay. I think Ratzia is talking to some colleagues. Okay, but in any event, yeah, so there are multiple benefits to filing an international application. Even though the initial costs are quite expensive, in the long run, it might save an applicant quite a lot of time. You'll receive a clear indication as to the patentability of an invention upfront before nationalizing in the various countries. Then also, as I said, it also allows an opportunity, when I discussed it with Hans earlier, that you can amend the specification during that international phase, and those amendments are then likely to be deemed amendments made in the national countries as well. So you won't have to then individually make those amendments in each country, because they're already part of the international application. So again, a cost-saving measure there. Okay, any questions regarding international arrangements? We will come back to the PCT, as I said, and look at it in greater detail when we look at the filing into South Africa. But any questions that we might have before we move on to this very important section of today's workshop?
Hi, Marto. Sorry.
Hi,
Sorry.
Ruth.
Hi. Sorry. It's Marco, right? Sorry.
Yes.
Just one question. I'm not sure if we spoke about it, but I just got interrupted by my partner. Sorry about that.
That's fine.
With regards to the priority, if you file PCT claiming priority, when you file national application following the PCT, does the client still enjoy the priority date or not?
Yes, so they do. So they'll still obtain the priority dates of that first filed application, even though it's outside of the 12-month period
Yes.
in which if they would have filed the application in terms of the Paris Convention.
Yes. Yes.
In terms of PCT, they do still enjoy that priority date. Yeah.
Okay, perfect.
Yeah.
Thanks. I just needed clarity on that. Thank you.
No, that's fine. It is very important to make sure, though, in terms of South African law, that the PCT application is still filed within 12 months. If it's not, and they missed the 12-month deadline, and this does happen where applicants still file their application, but it's outside of the priority deadline, then there should have been some request made to the international authority to allow for condonation of the late filing of that PCT application. And the practice that we follow in South Africa is still to make a request to the South African Patent Office as well to recognize that allowance or of the condonation for the late filing. But that is a bit beyond the scope of this. Okay, great.
Thanks for that.
No, it's a pleasure, Ratia. Then we're moving on to, as I said, a very important section of the work, and that is looking at the patentability of an invention, what an invention is, what the various requirements are for patentability, some of the exceptions to novelty, how the courts will assess novelty and inventiveness. So quite a heavily loaded section. But I think we can continue. It's 11 o'clock now. And then let's carry on for a little bit before we take another break. So what are the basic requirements for obtaining a patent? So in terms of Section 25(1) of the Patents Act, an invention must be an invention by definition. Now, the Patents Act does mention or does have a definition of an invention, but it just says, it doesn't really add much. It just says it is an invention as per the requirements of this Act. So it doesn't expressly state what an invention is in the Patents Act, but it does provide a list of exclusions from what would be considered an invention, and therefore some exclusions that are not deemed capable of being patented in South Africa. And we'll look at those in a little bit more detail as we move on. But the invention must be an invention in terms of the South African Patents Act. Basically, anything that is not excluded from the exclusions of the Patents Act is an invention. Then one of the most important requirements is that the invention must be new. So it must have synonymously novelty. And at which stage it is considered to be new, we'll have a look at. Then the invention must involve an inventive step. Or otherwise, what is also synonymously used is that it must not be obvious. So it must involve an inventive step or not obvious to a person that is skilled in the art. And when we refer to the art, I mean the technology relating to that specific invention. And then the invention must be capable of being used or applied in trade or industry or agriculture. I've never come across an instance where an invention does not meet one of those requirements. So, as we said, in order for an invention to be patentable, it must meet certain intrinsic and extrinsic requirements, and then the most important of these are found in section 25.1. So if we have a look at section 25.1, it says that a patent may be granted for any new invention. So it must be new, it must be an invention, which involves an inventive step, and which is capable of being applied in trade or industry or agriculture. Now, what is the intrinsic requirement when it comes to patentability? That is, again, speaking to the invention itself, that the invention, by its very inherent nature, must be an invention per se in terms of the requirements of the Act. And as I said, anything that does not form part of the list of exclusions of what an invention is therefore capable of being patentable or being patented. So when we look at an invention and the intrinsic requirement of an invention for the patentability requirements, section 25.2 states that anything which consists of a discovery, a scientific theory, a mathematical method, literary, dramatic, musical, or artistic work, or any other aesthetic creation, a scheme, rule, or method for performing a mental act, planning a game, or in business, a program for a computer, the presentation of information, shall not be an invention for the purposes of this Act. So this is the exclusion of what would be considered an invention. So anything that does not fall within one of these exclusions is capable of being patented in South Africa. But why are these exclusions there? So if you consider a discovery is not necessarily intellectual property. It is something which nature has already created, which already exists in nature. There might be a method of extracting something that has been discovered, and that method of extraction might be patentable itself. But a compound, if we considering a plant, so if there's a natural compound that was discovered, that compound itself is not patentable because it is merely a discovery, but the way in which it is extracted or processed for human consumption, for instance, that itself may be patentable. But a discovery cannot be patentable because it is something which has already been created by nature. It has always existed. A person hasn't expended any mental capacity in creating the product which has been discovered. Hans, yes, you have a question.
Yeah, thank you. What if I discover, let's say, an oil, like that a place has an oil mine, would that be not okay? Obviously, it's not going to be patentable, but then under what IP can I protect it?
So is it a new type of oil, or is it just a regular
regular
field?
oil. A regular
oil
field, yeah.
Yeah, I mean, there's no real intellectual property at play there. That would have to come down to mining rights I'm assuming in order to be able to extract that. Yeah, so that would fall outside of the ambit of intellectual property. The only way that intellectual property will come into practice is if there is a new method of extracting the oil that was discovered in a site.
Okay, thank you.
Okay. So basically anything which nature has created then cannot again be invented. It has always been in existence. Then a scientific theory is also not considered an invention. And that is because the scientific theory is just a natural explanation of some aspect of the natural world. So again, tied in with the discovery, it is just a method of explaining an occurrence of something that already exists in the natural world. And this is very applicable to theories relating to physics, for an example. And then a mathematical method, as you'll see, also one of the exclusions, which is also closely linked in with a scientific theory. So where you have the theory of Pythagoras as an example, it's merely a method of explaining something that already occurs in the natural world. Speaking of Pythagoras theory, I actually read an interesting article recently where it was believed that, it's always been held that Pythagoras was the mathematician that put the theory of Pythagoras together. But there's now texts that have been discovered from the Mesopotamians that far predate Greece's finding of the theory of Pythagoras. So kind of debunks that he was the founder of the theory of Pythagoras. Just something interesting to add there. Then,
hello, Mark.
Yes, TK. We've lost your audio again, TK. Okay, TK, we'll come back to you once your sound is sorted out. But then moving on to the next exclusion, that is a literary, dramatic, musical, or artistic work, or any other aesthetic creation. Why would you think that these are excluded from patentability?
Because it's already protected in the form of copyright.
Yeah, exactly. So there is sui generis law in the forms of copyright, and then also when you're considering aesthetic creations, that's more within the ambit of design law. So there is law that already protects works that are more of an artistic nature, and therefore are excluded from patentability. Then you also have a scheme, rule, a method for performing a mental act, playing a game, or doing business, which is also excluded. And that is because these are considered to be essentially mental steps or methods of applying one's mind. So the rules of how to play a card game or a board game such as Monopoly, those are not considered patentable because it's merely just setting out mental steps on how to perform something, and not necessarily a new creation. Then moving on to F of section 25.2, a program for a computer is again excluded from patentability, and for the same reason as literary, dramatic, musical, artistic works are excluded. That is because it is protectable in terms of the Copyright Act provisions, where computer programs are protected by copyright. So the source code that directs a computer in order to perform a specific operation or function is protected by copyright. Where a program for a computer is used in an invention to perform a specific function, and it solves some solution to a technical problem, then as a system, it is likely to be protectable as an invention. And you can read more up on that on one of the articles that I sent through to you, looking at the patentability of computer programs. But the source code itself is not protectable as a patent. then the presentation of information, again, is not considered an invention for the reasons that it is, once again, within the ambit of copyright law. So those are all the exclusions that you need to know of what is not considered an invention for the purposes of a patent. The next slide is basically just touching on each of the various exclusions. So I'm not going to go through that again because we have covered all of those. But again, just when looking at discoveries, it is important to note that inventions require some creative thought of a human being. So therefore, something that does exist in nature cannot really be created. How should Section 25(2) be interpreted? Sorry, just moving back to TK, I see he has posted a question. So he asked, what if the mathematical method or calculation helps create a new compound or composition? It would be similar to the instance where a computer program is used to solve a technical solution. The same principles would apply, yeah, but the claims of the patent itself would likely not be directed towards the mathematical method or calculation, but rather to the compound or the method in developing that new compound. And if that method requires that this calculation be used, then it is patentable, but it won't be a standalone protection for that mathematical method. It's rather the overall protection of the invention to obtaining the new compound or composition. Okay, but then moving on to Section 25(3), TK, does that answer you? Sorry. Great, thanks. So Section 25(3) basically tells us how to interpret Section 25(2), the exclusions. And it says that the provisions of subsection 2 shall prevent only to the extent to which a patent or an application for a patent relates to that thing as such, anything from being treated as an invention for the purposes of this Act. So this tells us that Section 25(2) must be narrowly interpreted. And that is why I say that, if you are using that mathematical method or that computer program, it relates only to that part of the invention as such. So very narrowly interpreted and the literal interpretation of the words from the Act. But where it is used as a system and is required to obtain the results for that invention, then it is likely to be patentable. But as it relates to a mathematical method as such, or a computer program as such, where you're only seeking to protect the source code, that itself will not be patentable. And that is thanks to the provisions of Section 25(3) that states that those exclusions must be narrowly interpreted, and it relates only to that thing as such. Unfortunately, there is no case law in South Africa that interprets Section 25(2) and Section 25(3), but there has been consideration for similar provisions across the world, and most notably the Boards of Appeal of the European Patent Office. And the South African courts of the Commission of Patents and the appeal courts will often look to the development of the laws in the European Patent Office because the laws are so similar between South Africa and the UK Patents Act. The South African's Patent Act as it stands is verbatim, almost verbatim to the UK Patents Act in many regards. So a lot of similarities between those jurisdictions and with Europe. So the Boards of Appeal of the Europe Patent Office, when they were presented with the interpretation of the exclusion of a computer program from patentability, held that if there is a problem that requires a technical effect, so if the patent specification describes matter that is excluded from being considered in an invention in order to obtain that specific technical result, then the patent itself may still be validly obtained. So where it serves a purpose in obtaining the results and has some technical effect to a technical problem, you may still be able to obtain a patent right, even though there is the use of one of the exclusions from patentability. Okay, is everyone happy with section 25.2 and 25.3?
Marco, can you give us an example? Sorry, yeah, people are putting their thumbs up, but
Okay. An example of some of the exclusions.
something that's excluded, yeah. Would it be like a
Okay, let's go.
mathematical equation or a compound?
Yeah,
or...
so as I said, with the mathematical method, it would basically be a mathematical theory, such as the theory of Pythagoras, in order to determine the length of one side of a triangle. That's purely a manner in which to prove something that already exists. So that would be one of those. Then when you're looking at scientific theories, an example that I have there is also, the laws of thermodynamics, Newton's laws of motion, where every action has a reaction. These are all things that happen naturally and would be considered a scientific theory. So most scientific theories that are used to explain something in nature is then considered a scientific theory. When it comes to literary works, as we know, those are quite straightforward. It would be a book, a sculpture, artistic work, some musical production or sound. A lot of times, when it comes to schemes, method of doing business as well, an example of that would be what comes to mind, like a pyramid scheme, where there's this, there's this scheme in order to, get so many returns on X amount of investment, but in order to do that, you must do X, Y, and Z. That is a scheme. So a pyramid scheme is definitely within that ambit. A method of
sorry, Marco.
Yes.
Sorry to interrupt you, but I understand the exclusions as they stand. But what I was trying to maybe, I didn't position the question correctly is, so if I need to interpret section 25.3, the exclusion would be exactly as you've listed them against any new invention.
Yes.
So I would have to read those exclusions into the specification.
Yes, that's right. Yeah.
Okay, that's exactly what I needed to understand.
Yeah, so if you take a touch screen phone, for example, so if you've got your cell phone, that's got a touch screen, there is a problem, or there was a problem that existed where, you'd have to press a button, a physical button, in order to type. With a change in technology, it's now a touch screen. Okay, there's no physical buttons that we're touching. But in order for the phone to function, so it's picking up, I'm pressing number 2 on my phone without a physical button itself, there must be some code that is directing the phone to execute that operation that I'm pressing 2 on my phone, even though it's no physical button. So there is code, software code, that would otherwise be excluded from patentability, but it is performing a very specific function to a technical problem where I no longer have a physical button. I'm using a screen to communicate with my phone. And in that case, the overall system, the overall interplay of how the hardware of the screen itself is engaging with my finger, interacting with my finger, and how it translates to directing the phone into executing that operation itself, that would be patentable, even though there is code being used to translate the input into the execution of an operation. I hope that helps a little bit.
No, it does. Thank you very much. I
Okay.
think that illustrated it very well. Thank you.
Okay, pleasure. Okay, but apart from Section 25(2), there are also other unpatentable inventions provided for in the Patents Act. So if we have a look at these other provisions, you have Section 25(4). That states that a patent shall not be granted for an invention, the publication or exploitation of which would generally be expected to encourage offensive or immoral behavior. So if we just go through that again, it says a patent shall not be granted for an invention, the publication or exploitation of which would generally be expected to encourage offensive or immoral behavior. I mean, that is quite a subjective exclusion. What might be immoral for one would not be immoral for somebody else, for instance. But I mean, it would be within the general consensus of the public's morals and their standing to those morals. So an example that I could possibly give you there would be a date rape drug, for instance, where the specific use of that date rape drug is to perform something that is unlawful and wholly immoral. Also, stem cell related inventions might be considered to be something that is immoral. Might not be offensive, it could be to some, but to others not. But again, this is quite a subjective application of what cannot be patentable. Hans, you have a question?
Yes, this is very, very subjective. I mean, how would an examiner sitting know that this is moral or immoral?
Yeah, that's what I'm saying. It's quite tricky because it would most likely come down to the public's convictions and what are the public convictions at the time of that examination taking place, or if it's before the courts. In South Africa, that is something that will be before the courts to determine. And this is something that I have never seen raised in South African context at all.
In patents, yes,
Yeah.
because we have this thing going on of I don't know if you know McG, the saga between McG and the other lady. McG is a podcaster, so
Okay.
he said some things that apparently was not taken well by society, and yeah, so
Yeah.
so that's where my question comes from. When do you know when you are moral and not immoral?
Yeah, it's very difficult, and as I said, it's not something that's really been applied in South Africa that I'm aware of. You know, you might also consider the case of Woolworths and the baby carriers some years back, where Woolworths was selling baby carriers when compared to another lady's products did look similar to some degree. And there was a massive public outcry against Woolworths, you know, because Woolworths is this big corporation. They're always seen as the bully. But in fact, that lady had no registered intellectual property over her designs for that baby carrier. So, you know, if you have a look at it on paper, Woolworths was not in the wrong. You know, and I'm not saying this to defend them, but that's just on black and white. You know, Woolworths were actually entitled to use that carrier. You know, there were differences in it. It might have been that there's some copyright issues, but if you're looking at a design perspective, there was no IP for the design of that baby carrier, and it was the designs that were in dispute. And Woolworths was entitled to do that if there's no intellectual property. But because there was such a public outcry, you know, and because Woolworths has such a reputation to uphold, you know, it could be considered that maybe their behavior was immoral in that instance, or that doesn't relate to patents or an invention. But it just goes to show how the public can influence what is considered immoral and what is not immoral.
Then
Thank you.
TK also has a question here that what if immoral in a particular country, for example, Middle Eastern country, but considered moral in another country? What happens to the patentability in that country? So again, it would come down to the national laws of that country. So even though it's deemed moral in one country, it may be deemed not immoral in another country. So it could be the case that you'll obtain a patent in one country and not a patent in the other country. Remember, it comes down to the national laws at the end of the day. Okay, then moving on to section 25(4)(b), it says for any variety of animal or plant or any essentially biological process for the production of animals or plants, not being a microbiological process or the product of such a process. So what this provision is telling us is that it is not possible to obtain, for example, a patent for a new breed of a dog. So you can't cross a Ridgeback with a Jack Russell, and I know it's an odd combination, but that is the dog that I have. It's a Ridgeback cross with a Jack Russell. My suede is not patentable. So it's not patentable to obtain a new breed of a dog or a new variety of a plant, as an example, in terms of the Patents Act. When it comes to plants, again, as with copyright, there is sui generis law where you have the Plant Breeders' Rights Act that does provide for the protection of a new variety of a plant. If you go to Woolworths or Checkers, you'll often see trade names used for grapes. You've got the cotton candy grapes that are seedless, that are incredibly sweet, supposed to taste like cotton candy. And that is something that has either been crossbred with various species over time of plants, or that has been genetically modified in some manner to exemplify specific characteristics in that fruit. Again, that is not patentable in terms of the Patents Act, but for plants, it is protectable as a plant breeder's right. Then if we consider biological processes, what is a biological process? Because it refers to any variety of animal or plant or any essentially biological process. So again, that would be methods of crossing, interbreeding between species, different varieties, that is then not considered patentable. However, it says not being a microbiological process or the product of such a process. So a microbiological process itself is patentable, and microbiological process can be used for various reasons. Most importantly would be for the development of antibiotics for public health care, or the cultivation of a microorganism to produce some useful product. For instance, you'll have live cultures that are used in yogurts. Again, going back to Woolworths, if you look at some of their yogurts, they have Bifidobacterium as the live culture in there that supposedly has benefits for a healthy gut. And that would probably have been genetically modified in some way to extract specific characteristics and to express certain genes, and that would then be patentable itself. Okay, so when it comes to microbiological processes or the products of those microbiological processes, so an antibiotic, those are patentable in terms of the Patents Act. Any questions on section 25(4)? Yeah. Then when we have a look at section 36, although these are not expressly excluded, it does permit the registrar with the discretion to refuse certain applications from being patented where the invention may be contrary to well-established natural laws. So an example there would be a perpetual motion machine. And for any of those that are in practice as upcoming patent attorneys, this is something that you will deal with quite regularly, where an inventor will come to you with what they believe to be the most brilliant invention under the sun, and that is to infinitely generate energy. In terms of natural laws, it's simply just not possible to do that. So when invention is contrary to well-established natural laws, the registrar may refuse that invention from being, or that application being granted as a patent right. Then again, the registrar may refuse an invention which would be generally expected to encourage offensive or immoral behavior. So a very similar provision to section 25(4). But it is slightly confusing as to why on the one hand it says it shall not be granted, but then in section 36 it allows the registrar to make that discretionary choice. So which it is, I don't really know, to be honest with you. Then also the registrar of patents may refuse inventions which may be used in manner contrary to law. And the example that I've put up there is something that can be used in biochemical warfare. Just going back to section 25(4), you'll see that I have in bold highlighted regulation 28 of the patent regulations. And that is the requirements in terms of the Budapest Treaty that South Africa and many other countries have ratified. And that is where an invention relates to a microbiological organism. There must be a deposit made of that microbiological organism at one of the depositories, so one of the houses that are able to store that microorganism in a viable state. The reason being is that, again, any member of the public must be able to execute that invention. And for the furtherance of that innovation, they should be able to access that microorganism from the depository where that microorganism is housed. It's actually a ground of revocation if the patent specification doesn't stipulate where the deposit is made or what the accession number is, so the code to access that deposit. So your patent specification, if it relates to a microbiological organism, must be deposited and it must be stipulated in the specification. Otherwise, the patent can be invalidated on the basis that it doesn't. Then just some further requirements of inventions that have additional requirements in order for them to proceed through to grant are those relating to nuclear inventions. So an invention that relates to nuclear technology in terms of the Nuclear Energy Act does require the Minister of the Department of Mineral Resources and Energy's consent in order to allow that application to go to grant. And that is because the Department of Mineral Energy and Resources needs to establish whether that invention which relates to nuclear technology poses any threat to South Africa and whether it is in compliance with South Africa's non-proliferation regime. If it does not, then the Minister of the Department of Mineral Resources and Energy can refuse the further prosecution of the South African application. This does happen quite often. There are a lot of inventions that come into South Africa where it does relate to some nuclear energy, and I deal with those quite extensively, and I've never had an instance where the department has refused it. So please do be aware of these additional requirements for nuclear related inventions, that you do need to obtain additional approval. So you'll basically provide the Department of Mineral Resources and Energy a copy of the specification informing them that the invention relates to nuclear technology. They will then conduct an assessment of that specification, and if they are happy that it does not contravene any of South Africa's obligations in terms of the non-proliferation regime for nuclear energy, they will then approve the further prosecution of that application in South Africa, and they will send through a letter to the applicant as well as to the registrar of patents informing them of their approval. But as I said, I've never had an instance where it has been denied. Hi, Lorraine, you have a question?
Hi, sorry, we probably will get to it when we get to the amendment section. But let's say, for instance, in your specification, you did not include where you said that you did submit a sample. Can that be added by way of amendment, or will that be seen as adding subject matter?
Look, so it doesn't necessarily need to be in the specification itself, but in the application, there must be some proof of the deposit being made. So it will be possible to include like the depository proof of the deposit with the application. So you can submit that to the patent office. You can late lodge that, and that should be acceptable. Otherwise, in terms of the amendment, it should also be allowed. I don't think that it would be considered new subject matter because you're not claiming that deposit itself. You know, it's just an addition. I'm just trying to think about that. It's a good question. Look, it could be that it was either a clerical error or it was erroneously omitted from the specification, in which case you wouldn't have any problem by including it. But it's also not going to be claimed subject matter. So you should be able to get away with inserting it by way of an amendment. Yeah.
Okay, thank you.
Yeah. Hans?
Yes, on that. So basically you're saying that there can be amendments on the specification and then it can be included in the claims.
No, so what I'm saying is that if the accession number was not included in the specification, it's not a claimed, you're not including that in the claims, you're including it in the description itself.
Okay.
Yeah. And in that case, I don't see that there will be a problem to that amendment.
But it's not part of the claims.
It's not part of the claims, no.
Okay, thanks.
Yeah. Okay, then if we move on to section 2511, again, a very important exclusion from patentability in terms of the Patents Act, and separate to the exclusions of section 25.2. Section 2511 states that an invention of a method of treatment of the human or animal body by surgery, therapy, or of diagnosis practiced on a human or animal body shall be deemed not to be capable of being used or applied in industry or agriculture. So if we just go through that again, it says an invention of a method of treatment of the human or animal body by surgery or therapy or of diagnosis practiced on the human or animal body shall be deemed not to be capable of being used or applied in trade or industry or agriculture. So a method of treatment of an animal or a human is not patentable because it is not considered to be industrially applicable. Now, the importance of this section, or let me rather pose the question to you, why do you think our Patents Act has this provision? Rather, who do you think this provision would most be applicable to? What profession would this be applicable to? Isaac?
Yeah, in the pharmaceutical industry.
You say the pharmaceutical industry?
Yes.
Okay. But do you think it's a pharmacist that would be conducting the surgery or therapy or
A
diagnosis?
surgeon.
Yeah.
Would
Okay,
it just
so
be healthcare professionals? Is
it's likely going to be a healthcare
specialists?
practitioner. It's going to be a doctor, a surgeon, or even a vet that has to perform surgery on an animal body. Now, when you consider, again, the morale of the public, and imagine the scenario where a patient is rushed into the emergency room, there is this new groundbreaking method of performing a surgery to remove an appendix, as a silly example. But let's think about this hypothetical situation. A patient's rushed into the emergency room, they're losing a lot of blood, they're about to die, and the surgeon is obligated in terms of their oath, Hippocrates' oath, to save this patient. Now there is a patent in place to prevent a surgeon from performing a life-saving surgery. Is that not against the contraventions of public morale? I would think so.
Exactly. And that's what
yeah.
I thought. It's against morale.
Yeah. So if this was not included, you would have a situation where medical practitioners and veterinarians are actually prevented from performing certain functions, where they cannot perform a life-saving surgery, or they cannot diagnose a patient that has a life-threatening cancer. Because remember, it's not just surgery, it's therapy or diagnosis. So therapy in treating a patient for some disease that they may have. So that is why the South African's Patent Act has this exclusion. It's so that medical practitioners can still attend to their patients, whether it's animals or humans. And please be very careful when you look at the wording of this section. It refers to humans or animals, and not just surgery. It applies to therapy and diagnosis. So a lot of times in the exam, when there's a question posed on this, a candidate will only refer to a method of surgery, but it's not just relating to surgery. It relates to therapy and diagnosis, and it's not just for humans, it's for animals as well. So there's a lot that is contained within section 2511 that you need to be aware of. Interestingly, there are countries that don't have a similar provision. The biggest culprit being America. In America, it is possible to obtain a patent for method of treatment for surgery, therapy, or diagnosis. So you sit with a problem where an invention that was filed in America, where there's a priority application in America, includes methods of treatment claims, is then filed into South Africa, and it sits with these claims, which in terms of our law are not patentable. You have a bit of a problem. So you have to be able to overcome that problem as a patent attorney to advise your client on the best way forward. And we'll have a bit of a look at that as we move on. And that is going to be the Elon transdermal case. But before going there, our Patents Act does provide that the compounds and compositions themselves that are used in the methods of treatment, so the actual pharmaceutical or the surgical knife that is being used to perform the surgery, those themselves are, however, patentable. So compounds and compositions, whatever device is being used, that itself is patentable. It's just the method in which that surgery or diagnosis is made or conducted.
Isn't that similar to a computer program if we had to put it? Or is my thinking not correct? Because it's a process, right? It's like a method of doing business or playing a game.
When performing the surgery, yeah, I understand where you're coming from, right? Yeah, that I think that is a good comparison to make. But the compound itself, although that is a type of therapy and a process to that therapy, There's specific steps that have to be taken. Those steps themselves are not protectable, but the drug that is administered to treat a patient,
Understand.
that drug
Yeah.
itself should be capable of protection.
No,
Okay.
I understand that.
Okay.
Thank you.
Then you'll see that I also said that the use of these compounds and compositions applies to both first and second medical uses of a known compound or composition. And I'll touch on this as we go on to this Elon transdermal case. In terms of section 2511 and the use of compounds, there's only been one case in South Africa, and that is then this Elon transdermal case. But I think everyone is clear by what I mean a method of surgery or diagnosis or therapy, that's not patentable, but that the compound itself that is being administered to a patient is patentable. Okay, I think everyone's on the same page there, I hope so at least. But the Patents Act then does provide that compounds and compositions for use in those treatments are, however, patentable. And you'll see that I state that this applies to both first and second medical uses of a known compound or composition. Now, what do I mean by that? So, if you consider, let's take aspirin, okay? Aspirin, the active ingredient there is salicylic acid. That is used as a treatment for either pain or to treat a headache. Let's just keep it very basic. So you have aspirin that is used to treat a headache. And that was what it was first discovered for. I hope I'm correct. I might not be factually right, but let's base it on these set of facts that I'm giving you, hypothetical facts. So you have salicylic acid, which was discovered. So we've got a discovery, but it was extracted. It was treated so that it is safe for human consumption and is therefore patentable. Salicylic acid was patented for the treatment of headaches. But then it was later on discovered that salicylic acid also works as a blood anticoagulant and as a blood thinner. So the treatment of that compound serves a different purpose. It's not only for treating headaches and pain and fever, but it's also capable of being a blood thinner. Okay. A very well-known example as well would be that of Viagra for erectile dysfunction, which was actually the second use of Viagra. The first use was as a vasodilator. So again, you've got the same compound, but the treatment using that compound can be used for various types of treatments. And in that instance, it is still possible to protect the compound or the method that it is being used for. Now, if we have a look by what I mean when we have a look at this Elon transdermal case, it said that where a compound has a first medical use, so if we consider the aspirin that is used for headaches and fevers, but it also has a second medical use as a blood anticoagulant, then our case law holds that where it is a first medical use, so being for the treatment of a headache, you will claim the compound. So in the set of claims, now we haven't touched on the claims of a specification yet, but the claims of a specification define what it is that you're seeking protection for. It is where the monopoly exists. So it is what you are stating the invention is and what the protection is that you are seeking. So for first medical use, you're seeking the protection for a compound X, being salicylic acid, or a compound of salicylic acid, for use in the treatment of disease Y in a patient. Disease Y being somebody that suffers with migraines. Okay. And this is the structure that the claims need to take on in South Africa in terms of the Elon transdermal case. This was decided case law. If that salicylic acid, which is now something that is in the market, it is in the public domain, and that compound itself does not have any novelty because it is something that has previously been used, you are still able to obtain patent rights for the use of that compound. So you'll notice that the claim is not directed to the compound itself, but instead it is directed to the use of that already known compound, being the aspirin, in the manufacture of a medicament to treat a specific disease. In this case, now being the second medical use, which would be the vasodilator. Is everyone following me with this explanation? So our courts have held that if it's a first medical use of a compound where that compound was not previously known, then the claims must be directed to that compound and you will use this claim structure. But if that compound is known and the medical use is different to the first use, then you will use the Swiss type format of the claim, as this is commonly known as, being that it's the use of that compound in the manufacture of a medicament, so a new pharmaceutical that will be used to treat a different disease. Okay, so I hope everyone understands.
And then that would be patentable.
That is patentable, yeah.
It's used for a different cause, but from somewhere.
So it's the use, it's the cause that is different, and the use of that medication for that cause. So you're not necessarily obtaining a patent for that compound itself, but it's rather the use of that compound to treat a different disease that is patentable. Okay.
Yeah.
I'm getting some sighs.
It's too much.
Yeah, it is a difficult one to comprehend. But yeah, so that's currently, and I mean, this provision of the compounds and compositions being used as second medical uses is provided for in section 25(9) of the Patents Act, and we'll have a look at that as we go on. But I have explained it to the full extent here. But as I said, this is the way that the courts have held in terms of South African law. Those claims need to form into that structure where it is a first medical use or second medical use. And that actually arose from European case law, but since the decision of Elon Transdermal, European case law has again changed, and they've done away with this Swiss medical use claim format, where they are using the for use type form, whether it's a first use compound or a second use compound. In Europe, that is the approach that they follow, whether it's first or second medical use. But this is the case law in South Africa as it stands, and the way in which we need to draft our claims. Yeah, again, this is just some of the examples as to why there might be first and second medical uses. I think we have touched on this. So it's where the drug is initially developed for a particular purpose, and later research then finds that it's useful for another therapeutic area. It could also be that the drug failed for its first known use, but that new use results in an important therapeutic treatment. And then sometimes a compound for non-medical use is found effective for medical use, such as medicinal uses of marijuana. And there you can see we have the example of salicylic acid used for use in the treatment of headaches, and then the use of salicylic acid for the manufacture of medicament for the treatment of hypercoagulability. Everyone satisfied? Okay, I hope so. So we've now had a look at the intrinsic requirements of an invention. So being that an invention must inherently be an invention for the purposes of the Patents Act. Now we're going to look at the extrinsic requirements. And the extrinsic requirements are the legal standards that are stipulated in legislation that an invention must meet in order for an invention to be patentable. So that is now looking at novelty, non-obviousness or inventiveness, and the ability of being applied in trade or industry or agriculture. So if we just recap then on section 25(1), it says a patent may, subject to the provisions of this section, be granted for any new invention which involves an inventive step and which is capable of being used or applied in trade or industry or agriculture. Okay, so section 25(1 there provides for the extrinsic requirements to patentability. So when assessing the newness or novelty of an invention, at which point must an invention be considered new? And that is from its priority dates. So what is the priority date? The priority date is the date on which the first application in respect of that invention was filed. So anything that was before the filing date for that application for a patent is considered prior art. So that is material that has existed in the public domain and is considered to count against the novelty of an invention. So anything that existed before that filing date is prior art and may be used to destroy the novelty of an invention. So when the courts assess whether an invention is novel, will be from the filing date of that application. So you'll see that an invention is deemed to be new if it does not form part of the prior art immediately before the priority date of that invention. So if what you are claiming your invention to be did not exist before the filing date, then that invention will have novelty. It's quite a straightforward assessment. It either existed or it didn't. It's a factual assessment. But if we look at section 25(5), where it expressly stipulates when an invention is deemed to be new, it says an invention shall be deemed to be new if it does not form part of the state of the art immediately before the priority date of that invention. Okay, so it is telling us when we need to determine and assess novelty from. But the Act then goes further on to tell us what is considered to be state of the art, what is considered to be something that will destroy the novelty of an invention. And that is provided for in section 25(6). It states that the state of the art shall comprise all matter, that is, whether it's a product, a process, information about either or anything else, which has been made available to the public, whether in the Republic or elsewhere, by written or oral description, by use or any other way. So anything that is in the public domain anywhere in the world is considered state of the art or prior art. Okay. So as we now know, in an oral disclosure, as an example, a lecture, if I was up in front of the students presenting on my invention, that lecture itself, where I disclose that invention, would be considered prior art. A presentation that is being presented to students or to a panel would also be considered prior art. And this is often problematic when it comes to universities or organizations that have a specific function to perform research and development. Because they have specific ratings, NRF ratings as scientists, they obtain funding for their research and development. A lot of the times, scientists, professors, lecturers, people that are conducting research will disclose inventions when they shouldn't be doing that, because there is intellectual property that is protectable. And once that disclosure is made, it is now part of the public domain. And if no invention, no application was filed for that invention, it would then destroy the novelty of that invention and they won't be able to obtain patent rights. So it's very important, if ever you are dealing with clients of yours that are based at universities, that they are very aware of when the novelty of an invention is destroyed, and that they must maintain the secrecy of an invention until an application for a patent has been filed. So other examples of something that can be considered prior art will be written publications. So that could be other patent documents that are available, books, magazines, scientific papers, anything in television or radio programs, prior use by carrying out a method of manufacture or sale of an article. So where you have publicly used a method of performing a certain invention would be considered prior art, and then disclosure on a website. This one happens quite regularly as well. I had a client that it wasn't for patent, but it was for a registered design, where it was almost like a Transact plaster, medicated patch that you would apply, but it had a very specific shape and configuration. And they had, prior to filing their application for the registered design, disclosed images of that product on their website. And unfortunately, they couldn't obtain registered designs in South Africa. It was outside of the grace period applicable to designs for South Africa. So that is something that happens quite commonly. As you'll note, the disclosure must have been made available to the public, and it can be anywhere in the world. So if we go back to our introduction where we looked at the Venetian law, the industrial brevets of patents, that was the novelty requirement was localized within that dominion, so within the region of Venice. But South Africa's law and most countries have the requirement where novelty is destroyed on a worldwide basis. So where there's a disclosure anywhere in the world, it will count as prior art. I think there was a hand up. Was it Retabile? Did you have a question? Okay, let's see. Okay, and then in industry, we'll refer to the standard of novelty as absolute novelty. So South Africa has an absolute novelty requirement. Some countries do allow for a grace period where there is a disclosure of that invention. They do allow for a novelty period, grace period, within which you can still file your application. But that's not true for South Africa. And even if that is the law in their country, it's not applicable to South Africa. So if they've relied on a grace period in their country, that grace period doesn't extend to South Africa. We still have an absolute novelty requirement. Okay, there are then some exceptions to novelty in terms of the Patents Act. And I've categorized these into two broader categories. So the one is where there's no disclosure of the invention. So it's not publicly disclosed, but the novelty of that invention is destroyed. And this is where there is a prior patent application in terms of Section 25(7). Now, Section 25(7) states that the state of the art shall comprise all matter contained in an application open to public inspection, very importantly, for a patent, notwithstanding that the application was lodged at the patent office and became open to public inspection on or after the priority dates of the relevant invention. If that matter was contained in an application both as lodged and as open to public inspection, and the priority date of that matter is earlier than that of the invention. Okay, so this is quite a mouthful to digest. Basically what it means is where you have a scenario where you have co-pending applications. So you have an application that was filed at the South African Patent Office. That application is not yet open to public inspection when it is lodged at the Patent Office. So you have application A. Then you have application B for the same invention that is filed by a different applicant. But because application A is not yet open to public inspection, applicant B for application B is not yet aware of the disclosure in A. But if A becomes open to public inspection, so if it goes through to grant and it becomes a public document, it is still considered prior art against B. Even at the time when B was lodged, it was not known to that applicant that there was an application for that same invention. Application A will destroy the novelty of invention B. Okay, so the requirement is two co-pending applications. One has an earlier filing date than the other, and the earliest filing date application becomes open to public inspection. That application is prior art against the second filed application. Just importantly for exam purposes, in the past I have asked that you discuss what the state of the art is, and a lot of candidates immediately jump to section 25.6, but they then completely forget about section 25.7, where section 25.7 expressly states the state of the art shall also comprise. So it is important to note this provision, and that it is also state of the art where there is a co-pending patent application. Okay, so just a little hint for the exam. And the same applies to the second provision where there's no disclosure of an invention, but the novelty is destroyed. And that is where there is secret commercial use. So Sarah, you have a question.
Hi, Marco. Yes, please could you just re-explain that scenario with application A and B again?
Okay. So you'll have an application that was filed for an invention. That's the first filed application. When that application is filed at the patent office, it's not open to public inspection at the date that it's filed. It only becomes open to public inspection once it is granted. So several months down the line, when it is granted, is that a public document. So when it's filed, it's still a secret document at the patent office and the public doesn't have access to it. So that application is filed at the patent office. But then you sit with a situation where a third party, so somebody different to this first applicant, files another application that relates to the same, or it is the same invention. Okay, so let's say it's the same invention. At the point that they filed their application, the first filed application is still a secret document. So at the time the second application was filed, that applicant was not aware of the existence of this application. But because the first filed application has an earlier priority date and it later becomes open to public inspection, it is still considered prior art against the second filed application, even though that at the time the second application was filed, that applicant was not aware of the existence of the first filed application. Does that assist, Sarah?
Yes, it does. Thank you so much. I understand.
Okay, pleasure. The requirement is obviously that that first filed application must become open to public inspection. So if that application was abandoned by the applicant and it doesn't proceed to grant, then it will remain a secret document and it is not considered prior art. It's only if it was publicly disclosed. Yes, Hans?
In the case where the applicant B gets a grant before the publication of applicant A, what happens?
It's still prior art.
Say again?
It's still considered prior art.
Yeah, but then say I'm already producing whatever you applied for.
Yeah.
Yeah. So what happens? Like I get granted on an applicant that you filed before me and I filed after you.
Yeah, I mean it's a tricky situation, and I think you'll need to turn to the courts for some remedy in that instance. But as the law stands, it's the rights are grant or sit with the person that was the first to file.
Okay, thank you.
Yeah. So there's no remedies in terms of the Patents Act what would happen in that scenario. So it would have to be the courts that would make a decision on what happens in that case. Okay, but then turning back to the situation where there's no disclosure of the invention, but the novelty is destroyed, is where there's secret commercial use in terms of section 25(8). And this applies to where an invention is being used as a trade secret. So an invention that is used secretly, so there's no public disclosure of that invention. The use of that invention itself is contained within the confines of that organization that is using it or manufacturing it. So where it is used secretly and on a commercial scale within South Africa. So it's very important to note that it's only within the Republic. It is also deemed to form part of the state of the art. So in this scenario where an invention is being used secretly, but on a commercial scale in South Africa, that is considered prior art against another invention. Okay. And this, as I said, is mostly applicable to trade secrets, where trade secret is being applied in manufacturing a product, for instance. So a method that is being used to manufacture products, and that method has intellectual property attached to it, then that is considered prior art. But again, it is within the confines of South Africa. So that method of manufacture, or the use of that trade secret, must be within the borders of South Africa. If it was used in another country, it would not be prior art. Then the second category that relates to the exceptions to novelty is where there is a disclosure of an invention, but it is not novelty destroying. Okay, so you have disclosure of the invention, but it is not novelty destroying. And we have touched on one of these already, and that is the second medical use of a known compound. So if we look at section 25(9), section 25(9) expressly states that in the case of an invention consisting of a substance or composition for use in a method of treatment of the human or animal body by surgery or therapy, or of diagnosis, practice on the human or animal body, so a regurgitation of the method of treatment provisions of section 25(11), the fact that the substance or composition forms part of the state of the art immediately before the priority date of the invention shall not prevent a patent being granted for the invention if the use of the substance or composition in any such method does not form part of the state of the art at that date. So, as I said, we did touch on this quite extensively already. Section 25(9) permits the protection of a compound where it is a second medical use of a known compound already. So because that compound has already existed, does not destroy the novelty of that invention if the use of that compound is for a different treatment. Then another exception to novelty where there is disclosure, but it does not count as prior art, is where there has been prior knowledge or publication of the invention that is excused under specific circumstances. So section 26 provides that a patent shall not be invalid by reason only of the fact that the invention in respect of which the patent was granted or any part thereof was disclosed, used, or known prior to the priority date of that invention, if the patentee or his predecessor in title proves that such knowledge was acquired or such disclosure or use was made without his or her knowledge or consent, and that the knowledge acquired or the matter disclosed or used was derived or attained from him or her, and if he or she learns of the disclosure, use, or knowledge before the priority date of the invention, that he or she applied for and obtained protection for his or her invention with all reasonable diligence after learning of the disclosure, use, or knowledge. So that's really a mouthful. And I'm really hoping that the draft patents bill that should hopefully be coming out soon condenses the language a little bit, so that we don't sit with lectures that are so long and me stumbling over my tongue. But anyways, what this provision basically provides for is that if there was an unauthorized disclosure of knowledge of the owner of that intellectual property without their consent, then it is still excusable, that it will not be considered prior art. There is the caveat, though, that the applicant must have made steps to obtaining patent protection for that invention with all reasonable diligence after learning of that disclosure. So if the proprietor of that invention discovers that somebody has disclosed the invention without their authority or without their consent or knowledge, then they need to make application for a patent as soon as possible once they learn of that disclosure. Okay, so that is the one provision under section 26. The other provision under section 26 is that as a result of the invention being worked in the Republic by way of a reasonable technical trial or experiment by the applicant or patentee, or the predecessor in title, or the applicant or patentee. So this is where there is a technical trial that is being conducted either by a research person or researcher, or some medical trial that is being conducted. So if it's a reasonable technical trial or experiment, that is not considered prior art. Okay, so those are some of the exceptions to the state of the art. So where there has been a disclosure of that invention, either by way of unauthorized disclosure or by way of a reasonable technical trial. So if ever a patent comes before the court and is the subject of revocation proceedings on the basis that the invention is not new, the courts need to apply the test for novelty, which was set out in the case of Gentiruco versus Firestone. It's a very lengthy case. I don't expect you to read the entire case for purposes of this module, only for your group 2s if you are continuing in the patent section. But for purposes of examination, you only need to know what the test is. And as I said, it's a very factual assessment. It's either it is part of the state of the art or it's not part of the state of the art. But what the courts will do is that they will have a look at the claims. As I mentioned earlier, the claims define the scope of the monopoly. They define what the invention is. So they will construe the claims. And by construing it, what they'll do is they will read the claim and break it up into its separate integers. So let's take, again, a very silly example. You have a container. The invention is a container for housing a fluid. It has a double wall, okay, so to keep my beverage hot or cold. And it has a cap, specifically a threaded mouthpiece and a threaded cap, okay, for closing of this product. So that's one claim. So I'm claiming the entire bottle. So I'm claiming the container for housing a fluid, which comprises a double-walled vessel, a threaded screw mouthpiece, and a threaded cap. A very badly drafted claim, but just a silly example. So that is the independent claim of this invention that is in the specification. What the courts will do is they will construe that claim and break it up into its individual integers. So they will say that this invention comprises the cap, one integer. They'll say it has a threaded mouthpiece, second integer, double-walled vessel, third integer. So they'll look at all those integers and break them, or look at the claim and break it up into everything that comprises that invention. So all the integers that form that invention are then broken up and construed. So that is what we mean by the patent's claim is construed. So they'll look at what those integers are. So basically a shopping list of what makes up that invention. So you've got A, B, C, D. Those are the integers for that invention. Then the court will consider the prior art that is being presented to the court that is supposed to destroy the novelty of this invention. And they will do a comparison between the construed claims and compare it to the prior art. If the prior art, let's say the prior art document, so we'll consider a document in this example, discloses all of those integers, then that document is prior art, and that prior art document will destroy the novelty of the invention. Okay, so it's a comparison of the integers of the claim with a comparison of a piece of prior art. The courts can only consider one prior art at a time. They cannot extract integers from various documents. So if you have 5 different patents that have existed, they can't take an integer from this patent, an integer from that patent. Everything must be found in one piece of prior art. Okay, so they cannot mosaic. That's what we refer to as mosaicing, where they mosaic everything to form the invention. Okay, the court is not creating that invention. They're trying to determine whether a prior art document or other prior art destroys the novelty of our invention. Okay, so very straightforward factual assessment when determining novelty. Everyone happy there? Okay. More recently, there was a court case as well, Merck Sharp Dome versus Cipla Agrimed case that was heard in 2015, where they said that the disclosure also needs to be an enabling disclosure. So the prior art document itself must actually enable a person to perform that invention itself. So it must be an enabling disclosure that would have existed. So it's not merely enough for those integers just to be, bless you, Cara. It can't just be the integers that have existed in a document. They must actually enable a person to perform that invention itself. So it's an enabling disclosure that must exist. And that brings us to the end of novelty. Right. Are there any questions on novelty? Yeah. So quite a lot that can be tested on for novelty. What is novelty? How do you test for novelty? What are some of the exceptions to novelty? Really quite a lot regarding novelty. Okay, so then moving on to section 2510 and dealing with inventiveness or not obvious to a person skilled in the art. Section 2510 states that an invention shall be deemed to involve an inventive step if it is not obvious to a person skilled in the art, having regard to any matter which forms immediately before the priority dates of the invention, part of the state of the art by virtue of subsection 6, and disregarding subsection 7 and 8. You can not, subsection 7 and 8 deal with the co-pending application scenario. So co-pending applications are not considered for inventiveness, only for novelty. So a co-pending application cannot be used when assessing inventiveness, can only be used for novelty. Again, as you can see, this is a very subjective test that is applied. So it says an invention shall be deemed to involve an inventive step if it is not obvious to a person skilled in the art, having regard to any matter which forms immediately before the priority date of that invention. So again, the date at which inventiveness is assessed is anything that existed before the filing date of the priority application is considered to form subjects to this test of inventiveness. But a very subjective test, because how is it determined? It is determined to involve an inventive step if it is not obvious to a person skilled in the art. So in this situation, the courts will often rely on expert witnesses when there is an attack on a patent where it is argued that the invention is not inventive. And the expert witnesses who would be people that are skilled in the art, will provide their testimonies in court. Their testimonies are not binding on the court, obviously, but they are used to educate the court and inform the court of what their views are on whether an invention is considered to actually be inventive. So is it something, an invention that moves technology forward? It does not necessarily need to be an invention that drives technology forward or is a step forward in technology. Inventiveness can also be a new way of performing something. So if there's a method of manufacturing a compound, there might be a better method of manufacturing that compound. So the outcome is the same. You're still getting the compound, but it might be inventive if that method of manufacture saves costs, saves time, is safer. And that could still be inventive. So it's not necessarily a step forward in terms of the product itself, but in terms of the inventiveness aspect, it could still be considered inventive. So it's not just a step forward in technology, but also, you know, like a sideward step, if I can put it like that, where the outcome is still the same. But as I said, a very subjective attack on a patent when it comes to assessing inventiveness. This is one of the grounds that is used most frequently in practice when a patent is attacked for invalidity, because it is something that is so subjective, and you can possibly persuade the court to move one way as opposed to the other, depending on how well you can argue whether this invention is inventive or not. So it's a ground regarding which, more than any other, the circumstances and facts surrounding the particular invention at times far outweigh the abstract, you know, principles, underpinnings, definitions of that invention itself. So yeah, it is indeed very possible to formulate a clear-cut principle on how inventiveness is determined, and when the courts need to apply their interpretation of whether an invention is inventive or not. So quite a subjective process. But do know that the expert witnesses are often called upon in order to make their argument, put their client's arguments forward, or who they're representing. The courts have tried to create a test for inventiveness, and this was set out in the Ensign Bickford versus AECI Explosives case from 1998. And yeah, the courts held that in order to determine inventiveness, whether an invention is not obvious to a person skilled in the art, they need to look at what is the inventive step said to be in that patent. So what is it that is considered to be inventive about this invention? Then they need to have a look at what the state of the art is. So what is all the prior art that existed at the prior, before the priority date of that invention? So what was in the public domain before that application for the patent was filed that would be considered part of the technology available to the public? Then they need to do a comparison as to how does this invention go above and beyond the prior art that is already available to the public. How does it differ from the prior art? And then having regard to that further development or the difference between this invention and the prior art, would taking that step in the invention be obvious to a person that is skilled in that art? Okay, but as you can see, you know, arguments can come in at every step of this test. As you may recall with novelty, the test for novelty, it's not possible to mosaic several prior art documents. So when arguing if an invention is novel or not, you can only do that comparison with one disclosure, when it comes to inventiveness, you look at all the prior art that is available, and you are able to take from various technologies and mosaic it in determining that if a person skilled in the art considered this prior art, then it would have been obvious to them that this step is inventive or not. Okay, capable of being used or applied in trade or industry or agriculture. There's not much to be said here. As I said, it's a question of facts. Either the thing can be used in industry or can't be used. But obviously it must be capable of being used. So it cannot just be an idea. It must be something that you can put into practice, that you can apply then in trade or industry or agriculture. So you can just have a look at this slide. I'm not going to go through it in further detail. I've got a video that I would like to play for you. I'm hoping that the sound works and that everyone can hear it. I'm just going to check that my settings are correct. If you'll just bear with me for a moment. Okay, so grab the popcorn. Let's watch the movie. So this is an extract from the movie A Flash of Genius. And the reasons why I'm showing this video to you will become clearer after you've watched the snippet from The Flash of Genius. But what the movie is about, and it's based on a true story, so ever you do have the time or you have access to the movie, please do watch it. The gentleman that is the subject of this movie was an inventor of the intermittent wiper blades for a car. And he had terrible eyesight. He had a problem with his eyesight. Sorry, everyone. There's just somebody wanting to join. Okay, so the inventor had poor eyesight, and when he had to drive at night in rain, the continuous motion of the wiper blades made it even more difficult for him to see the road ahead of him. So he had then invented the intermittent wiper blade. You know, so in all cars today, you can adjust the variable speed at which the wiper blade moves. You know, either faster or slower, or takes a break every so few seconds. And that was the invention that he had developed, and he had pitched his invention to the Ford Motor Company. And they were then showed some interest in the invention, but he never heard back from them. He then attended a car trade show, and Ford had released a new vehicle onto the market. And one of the selling points of that new motor vehicle from Ford was that it has these intermittent wiper blades. And this is basically where they're standing in court arguing that they had infringed on his patent. He obtained a patent for the intermittent wiper blades, and Ford, without his consent, then went ahead and implemented the technology in their new car. So hopefully this works. If not, please let me know. Okay, it doesn't seem to be playing.
PhD in electronic engineering, is that correct?
That's correct. I've taught for the...
So, Cora, can you maybe give me a thumbs up if you're hearing it? Okay,
PhD
thank you.
in electronic engineering, is that correct?
That's correct. I've taught for the past...
Yeah, so I think this snippet illustrates precisely what I mentioned earlier, that an invention doesn't need to be groundbreakingly new. You know, it can be using old technologies, compiled, arranged in a different way to obtain a new outcome, to solve a technical problem with a new solution. So just because the individual integers, as he mentioned in this snippet, you know, the capacitor, whatever else that was mentioned,
all of those individual parts existed. All of those individual integers of this invention previously existed, but compiling it in a new way, you do get a new invention. So I think this is a good video just to express that point that I was trying to make earlier. You know, that because things that already are in existence doesn't mean that it has to be a groundbreakingly new development in technology. It's incremental steps in technology that get us to where we are in innovating. Okay. And I think that brings us then to the end of Section 25 of the Patents Act. Not just Section 25, you would have seen that we've touched on Section 36 and a few other sections relevant to novelty, inventiveness, what is considered an invention, what is excluded from from being an invention. And with that, I think we should break then for lunch. I see it is 20:01 now. Let's resume again, if that's fine with everyone, at 1:30. So you'll have about a 50-minute break. I think that's ample time to continue to stretch our legs and just to grab something to eat. But before we do break, are there any questions on anything that we've discussed this morning, or anything that I need to go back on and reiterate? Okay, it seems not, but if they are, okay. Isaac, I see you have a question.
Yes. Afternoon, everyone. Yeah, Mark, my question is based on Section 25.7, the general, Section 25.7, where the exceptions to novelty, wherein the invention is used for commercial scale. So my question is, let me frame it in this way, that suppose we have somebody's using the product or whatever the invention for commercial use, and then somebody comes in with the same invention. Okay, like the first one uses the the invention for commercial scale without disclosing it in public, and then that person trademarks it, and then the other person doesn't know that there is an invention which has been trademarked, but then later on files for a patent. What would be, how would it be decided as to whether the other is infringing the very same product in terms of trademark, or will the person rely on a trademark, or the other one will rely on the patent? I don't know if my question is clear.
I am struggling to understand the question, Isaac, but if I thinking on what you're saying, so if there is a trademark on that product itself, and there are two products that now enter the marketplace where it's the same method of manufacture as an example that's being used, then they would have to rely on I'm just trying to think about this one. So it could be that there's a passing off in terms of trademarks, or a direct infringement of trademarks. So when it comes to the trademarks itself, they would need to rely on the Trademarks Act to enforce it. It could be, though, that the other party would argue, and that's a separate assessment. It doesn't relate to the invention itself. If there's an infringement of the trademark, it doesn't relate to the invention. The products themselves might be the same, but it would be a dispute, a separate dispute, as to the one relating to the invention. And I hope I'm on the right track with what you were asking. But where it is argued from the invention's perspective, and it's the same invention being used, then the one party would need to turn to the courts, either to invalidate if somebody obtained rights to that invention, that there is an infringement, or not an infringement, but that their commercial use, their trade secret, is prior art against the invention that somebody else has obtained. So if the third party obtained a patent for the invention, but it is being used on a commercial scale, then that party can approach the courts and invalidate the patent on the basis that it's not new, because they themselves have been exercising that invention as a trade secret. Is that,
yes, yeah,
does that answer the question?
Yes, it does answer the question, yeah.
Okay, all right, I'll ponder a bit more on that, but I think that is the crux of what you are asking. Okay, if there are no further questions, then we'll join again at 1:30. Enjoy your lunch and see you soon.